Good day, students. Welcome to today's online tutorial. I remain gracious Abako. In our last class, we discussed business law. Today's class is a continuation from where we stopped the last time. We were able to look at the meaning of business law, and I was also able to tell us that business law is the same thing as commercial law. We look at contracts and also types of contracts. Today, we are continuing from where we stopped the last time. Our objectives are: 1. State the essential elements of a contract. 2. Explain the process involved in termination of contract. And lastly, state the remedies for breach of contract. The first here, essential elements of a contract. Talking about essential elements of a contract, these are the things that must take place before a contract can be said to have taken place. Now remember, we said contract is an agreement that is backed up by law. Now there are some agreements you can reach into, and there are chances that one of the party may want to default or may choose, for reason best known to him, not to fulfill his part of the bargain or his obligation. Now the first is there has to be an offer. A definite contract, an offer must be made by one party to the other, and the offer must be unconditionally accepted. Yes, there has to be an offer from someone, and of course there has to be someone else to accept that offer. Now what happened here is that if there is no offer and there is no one accepting that offer, we cannot say there is a contract. Offer, for instance, let's say one propose to sell a product or service to an individual. So he has to approach the person who is in need of it, and if the person agree and accepts, given the terms and conditions, here we can say that a contract has taken place. Then we have acceptance. This is what happens after an offer comes. Acceptance here means that the buyer, for instance, has accepted the offer, or let's say the product or service that has been offered. Now, here it says a contract becomes binding once the receiving party agrees through a clear statement that they accept the offer. Without a clear statement of acceptance, there is no agreement. So there has to be an acceptance from the other party before we can say that a contract has taken place. Then we have intention to create legal relation. Yes, this has to do with law. When you hear the word legal, it is law, it is accepted, it is legitimate. Now, it says the terms of an agreement must state clearly that the parties intended to create legally binding contracts. There must be no clause that will exclude the courts. Now, if an agreement is backed by law, which is to say that agreement has a legal backing, it is legitimate, and as one of the ways you can actually see compensation from the other party if there is a breach or default is the fact that there is a document to that extent that you can easily use to serve as an evidence in a court of law that you actually went into a contract with someone. So such can be presented in the court of law, and the person in question will have no choice than to compensate you. So there must be some elements of law in that an agreement. Then we have, there must be valuable consideration. Now, consideration in the price for which a promise is bought, an agreement become contract when each of the parties gives or promise to give something of value to other person. Now, consideration here, what I'm letting us to understand here is that if both parties has reached an agreement, definitely there has to be something that will go in terms of value, whether money wise. So a party going into a contract, let's say the buyer and the seller So if the seller is able to convince the buyer to buy a certain product, the buyer definitely has to promise or has to pay the other party the value of the services or products that he has received from the other party. So a valuable consideration here, we are looking at either the monetary aspects of, as a sign that yes, there was a contract. Then genuineness of consent. Consent here has to do with the free will. Now, when one consents to something, it means that one is not being forced. Now, what we have is a contract can be avoided if it is found that one party do not properly consent or that they consented under duress. Now, to consent under duress here is that you are agreeing to something without your free will. You are being forced to accept what is against your will because you do not have a choice. So, agreement of the parties of a contract must not be obtained under duress, under influence, misrepresentation, or mistake. So if a contract can be said to be valid, it means that both parties, yes, that are involved in that contract must consent, must agree without anything attached, as in they must agree willingly with their free will to be involved in such a contract. Otherwise, such contract can be rendered void because a contract here is concerned about agreement between two parties in the sense that the agreement is not the first one. Then we have legality of objects in the contracts. Now the object here in question is that what's this thing that is binding two people together or two parties together, or what they are trying. Take for instance, let's say before one can say he's into a contract, like we know, it has to be legally it has to be legitimate, so to say. But in the case where such is against the law, in the case where it is not approved or recognized by the state, now such object can be seen as an illegal. Now, if one of the party breach, there is no way you can seek redress or go to court for compensation because the object in question here is not recognized, is not approved by the law. Then we have the last one. The parties must have contractual capacity. That what they're trying to let us know here is that both parties involved in this contract, they must not be a minor, they must not be minor, and it has to be that they are free, they are in getting themselves involved in this contract with their free will. Now it says those who may not have legal capacity to enter into a valid contract are people that falls into the following group. The first here is minor, that is 18 and under in most countries. In Nigeria here, if you are under 18, you are a minor. Then 18 and above, you can be said to be, you can be called an adult. So in this case, a minor cannot go into a contract. So if there's any contract that involve a minor, such contract can be said to be void. Prisoners, yes, you do not go into a contract with someone who is stuck in the prison. So it has to be someone that is actually free. Then those suffering from mental ailments, that we have all those mentally deranged people, those we call them insane, as in they are mad, so to say. You do not go into contract with them because the law does not make any provision for such people. Then we have bankrupts. Here, these are people who do not have the financial capacity to meet up with their obligation or promises. So you do not go into contracts with someone whom you know is financially incapacitated. Therefore, these are the things that tell you that a contract is not a legal one if these people mentioned here are involved in a contract. So these are the 7 elements that can make a contract a valid one. And we are looking at termination of contracts. Now, what are those things that can bring a contract to an end? The first is by performance. Now, if both parties have fulfilled their own part of the bargain, or they have actually fulfilled their obligations, yes, by mutual agreement, they cannot bring the contract to an end. By breach, yes, human nature, one way or the other, you see, people would want to go against the agreement that has been reached. But in this case, if there is a breach, now remember those essential elements of a contract. If there is a breach by one party, of course, you can as well go to the court of law, and probably you can as well terminate the contract. For example, we have here, it said, if the person in question does not perform on the agreed dates or delivers inferior goods as against what was agreed upon, hence such a contract can be terminated. By agreement of the party, a contract can come to an end when both parties agree to release each other from contractual obligations. Yes, by mutual agreement. So once they have agreed that, okay, they can no longer continue with the contract, such a contract can be terminated. By frustration, I think here we are looking at the natural phenomenon, things that are beyond the control of man. So the contract can be discharged when the subject matter or the basis of the contract has been destroyed or brought to an end by an act of God, e.g., flood, war, etc., or there has been a change in law. Okay, now we know there are some natural disasters that could come to interfere with contracts. Let's say there's an agreement that has been reached. For instance, let's say there's a property that was destroyed by flood, by just name it. Now remember, all these things are not in control of man. Now, should this come into play, this can bring a contract to an end. Now we have bankruptcy. If the parties involved do not have a financial means, definitely it can bring a contract to an end. Then illegality of objects. Now the object in question here, is it a legitimate one? Is it approved by the states? Now, if the answer is contrary, then such a contract can be terminated because it is not approved or recognized by the state. For example, we have prostitution and drug trafficking. As far as Nigeria is concerned, this prostitution is illegal and drug trafficking is illegal in Nigeria, but I don't know about other countries. So if one engage himself, in such an act, let's say you reach an agreement with a prostitute, for instance, let's say after taking advantage of the person in question and you refuse to fulfill your own part of the obligation, such cannot be contested in a court of law. Then let's see remedies for breach of contract, like the solution should a party, fail to fulfill his part of the agreement. Then we have, so the injured party can sue for damages. Yes, remember, from the essential elements of contracts, if the contract meets those conditions, then you can actually sue for damages. If the other person in question fail to fulfill his or her own part of the bargain, so you can sue for damages. 2, we have action for an agreed sum. Yes, through your lawyer, you go to the courts to contest the case, and if found that yes, you are actually entitled to such an amount of money that was agreed upon, definitely you will be compensated. The courts will mandate the person that has breached to compensate you. Then we have quantum merit. It says here the amount he deserves or as much as he has earned. The plaintiff will be awarded as much as is earned. Now, before, what he's trying to say here is that if there is for some reason that the contract, there is a breach, okay. Now, what he's trying to say here that before both parties can be restored to their original position. Now it says the amount he or she deserve or earn definitely will be awarded to the parties. Then we have 4, injunction. Now injunction here, when you try to seek a court order. The injunction here is say this is a court order which may be prohibitory. Now prohibitory or mandatory. Now prohibitory here is that when someone is being prevented from carrying out a particular act. By the time you seek a court injunction, definitely it's either the courts will prohibit the parties from carrying out a particular act, or they will mandate, which is to command a party to perform a particular act. So these are one of the ways of remedying breach of contract. We have rescission. It is an equitable remedy which allows a contractual party to cancel the contract from the beginning, ensuring that both parties are restored to their original position. This one is self-explanatory. So here, rescission here is that the both party giving the courts mandates, as the case may be, both parties may be restored to their original position, thereby cancelling the contract. Like the contract here can be said not to have existed. Okay, this is where we'll stop today. In our next class, we'll be looking at contracts of sales. Now, this is like a continuation of the topic business law. Okay, so we're looking at contracts of sales. So the assignment is gotten from WAEC 1991. The first one here says business relationships are deeply rooted in the law of contracts. A. What is a contract? B. State the essential elements of a valid contract. And lastly, briefly discuss any 3 of them. So you can submit your assignment using the Google Classroom. I look forward to receiving your assignment. And I do hope that you are also to say, I just believe you are reading your books, as in giving what have been treated so far. So I advise, if you have not been reading, I think you should start reading. This is the best time for you to read. Thank you very much for your attention, and do have a lovely day. See you next week. Bye.